The appeal in Stoffel Co against Grondona concerns the defence of illegality to a civil claim. Until relatively recently, there was considerable uncertainty as to the basis and scope of this defence, and in a series of decisions in the Supreme Court, conflicting views were expressed as to the correct approach and as to the direction in which the law should develop. This was resolved in Patel and Mirza in 2016, where the majority in the Supreme Court rejected the reliance principle, under which relief was refused to those who had to rely on their own illegality to establish their case, in favour of a more flexible approach, which openly addresses the underlying policy considerations involved and reaches a balanced judgment in each case, and which also permits account to be taken of the proportionality of the outcome. This appeal, and that in Henderson and the Dorset Healthcare University NHS Foundation Trust, the judgment in which is also handed down today, are concerned with the application of this new approach to illegality. Ms Grondona was a party to a mortgage fraud. In October 2002, she purchased a property, 73 Beulah Road, with the assistance of a mortgage loan from Birmingham Midshires Building Society. The mortgage loan was obtained by fraud. Ms Grondona dishonestly misrepresented on the application form that the sale to her by Mr Mitchell was not a private sale, that the deposit monies were from her own resources, and that she was managing the property. In fact, the purpose of the transaction was to raise capital finance for Mr Mitchell from a high street lender that he would not otherwise have been able to obtain. Stoffel Co solicitors acted for Ms Grondona, for Mr Mitchell, and for Birmingham Midshires in connection with the transaction. However, Stoffel Co negligently and in breach of duty failed to register at the land registry the transfer of the property from Mr Mitchell to Ms Grondona, the charge in favour of Birmingham Midshires granted by Ms Grondona, or the release of a prior charge. As a result of this failure, Mr Mitchell remained registered proprietor of the property, and the prior charge remained on the register. On the basis of that prior charge, further advances were subsequently made to Mr Mitchell. In 2006, Ms Grondona defaulted on the payments under the Birmingham Midshires charge, and Birmingham Midshires brought proceedings against her for a money judgment. She defended the claim and brought third-party proceedings against Stoffel Co, claiming to be indemnified for their negligence or breach of contract in failing to register the transactions. Stoffel Co defended the claim on the ground that the purpose of putting the property in the name of Ms Grondona and obtaining a mortgage was illegal, in that it was a conspiracy to obtain finance for Mr Mitchell by misrepresentation. They said that the purpose of instructing them could only have been to further that fraud. At the trial, the judge held that Ms Grondona was a knowing and dishonest participant in a mortgage fraud. However, applying the law as it was understood prior to the decision of the Supreme Court in Patel and Mirza, she concluded that the illegality defence did not apply. On the appeal by Stoffel Co to the Court of Appeal, by which time the Supreme Court had delivered its judgments in Patel and Mirza, the Court of Appeal held that the illegality defence did not bar the claim. Stoffel Co now appealed to the Supreme Court. In applying Patel and Mirza, the Court must ask itself whether enforcing the claim would lead to inconsistency that is damaging to the integrity of the legal system. In making this assessment, the Court should consider A, the underlying purpose of making the conduct in question illegal, and whether that purpose would be enhanced by denying the claim, B, any other relevant public policy on which denying the claim may have an impact, and C, whether denying the claim would be a proportionate response to the illegality. The Court will be concerned to identify the policy considerations at stages A and B at a relatively general level. When considering proportionality at stage C, on the other hand, it is likely that the Court will have to examine the particular facts of the case in detail. However, it may not be necessary to consider proportionality at stage C if the court considers at stages A and B that the claim should not be barred by an illegality defence. In considering stage A, the court observes that Ms Grondona had committed a serious criminal offence. However, denying her claim would not enhance the underlying purpose of the prohibition on mortgage fraud. Fraudsters are unlikely to be deterred by the risk that they will be left without a civil remedy if their solicitors prove to be negligent. On the other hand, allowing Ms Grondona's claim would enhance the protection that the law provides to mortgagees and other members of the public, which is a further underlying purpose of the prohibition on mortgage fraud. By the time of Stoffel Co's negligence, it was in the interests of both Ms Grondona and Birmingham Midshires that the transfer should be registered. Turning to stage B, denying Ms Grondona's claim would run counter to a number of important public policies. In particular, it would be inconsistent with the policy that solicitors should perform their duties to their clients diligently and without negligence, and with the policy that the victims of solicitors' negligence should be compensated for the loss they've suffered. In the court's view, denying the claim would also result in an incoherent contradiction in the law, because the law accepts that an equitable interest in the property passed to Ms Grondona even though she was engaged in mortgage fraud. In balancing the policy considerations at stages A and B, therefore, this indicates that Ms Grondona's claim should not be barred by the illegality defence. In these circumstances, there is no need to consider proportionality. However, the court does address it, concluding that it would not be proportionate to deny Ms Grondona's claim because it is conceptually entirely separate from the mortgage fraud. Finally, the court observes that enforcing the claim would not allow Ms Grondona to profit from her own wrongdoing. In any event, following Patel and Mercer, the court's focus should be on the need to avoid inconsistency that is damaging to the integrity of the legal system. While the question whether the claimant will profit from the illegality remains a relevant consideration, it is no longer the true focus of the court's inquiry. For these reasons, the appeal is dismissed.